Well, hello to all of my methodical researchers out there. Today we're going to talk about secondary sources in general and how to evaluate them. We've discussed this a little bit already in the context of evaluating a treatise or legal encyclopedia for the purposes of preliminary analysis. But secondary sources have a variety of uses in legal research beyond this preliminary analysis stage. Accordingly, they come in a variety of forms to meet a variety of needs. As we discuss these different forms, we'll briefly mention many different types of secondary sources, giving you some basic knowledge about these different types of sources that you can rely upon if you ever think that one of them fits your needs. So, it is often helpful to think about evaluating secondary sources by using a variety of different metrics that can serve as a sort of guide to whether any particular source that you find might be a good fit for your research at that particular moment. So our first metric is one that we have some familiarity with already from our discussion of treatises. It asks whether our source is more scholarly or more practical. Is our source erudite? Does it have a lot of astute analysis? Does it inquire into the theoretical underpinnings of the law? Does it possess an academic pedigree? If so, it's probably more scholarly. The quintessential scholarly source is the law review. Other good examples come in the form of some of the more well-known and well-regarded treatises, like the Wright and Miller treatise that we looked at in our earlier video on federal practice and procedure, and the Nimmer copyright treatise that's discussed in your textbook. Now, generally, when you're researching legal issues that are more novel and you're making legal arguments that are rooted in policies and values instead of necessarily strictly based on precedent, scholarly sources will be particularly helpful. Although often you're also going to find that these sources are so expansive in their coverage that they can be useful for many different purposes. Now, on the flip side of these scholarly sources, we also have practical sources. These are designed to cater to the real needs of attorneys litigating cases right now. These usually contain fewer citations, fewer sources, and they focus more on giving practical advice. They might be formatted in a way that makes them just very easy to quickly skim, and that can make them super useful when an attorney is pressed for time. They need to be more efficient with their research. They aren't going to include as much analysis unless it just seems absolutely necessary. And they aren't necessarily going to address, novel or unresolved legal topics or issues. Now, treatises, of course, are a really broad category, and you will find that some of them fit more on the practically oriented side of this metric. And you can often identify these because the title might even include the word practice, but not always, of course. I especially like the LexisNexis series of practice treatises in this category. Bar journals are another good example that you can run into. They contain various articles discussing recent developments in the law that practicing attorneys just need to know, but they don't necessarily have a lot of in-depth analysis. You'll want to use these more practice-focused sources when the matter that you're researching is more routine, and it doesn't necessarily include a lot of factual wrinkles to complicate things. But really, of course, it's more of a spectrum. Legal encyclopedias and ALRs are definitely more practice-oriented than they are scholarly, but they're less practical than some of the practice treatises that you might run into, such as that Lexis DUI treatise that we looked at earlier in this course. Law review articles are usually, as I said, quite scholarly, but some articles in law reviews, such as student notes or case notes, can sometimes be pretty practical, so you do have to look at the sources that you actually use with a critical eye. Now, our next metric is a little more straightforward. Is the source making a normative claim or giving you an objective description of the law? Is the source making an argument about what the law should be, or is it telling you what the law actually is? We'll sometimes refer to this same idea as the distinction between prescription and description. The chief source that you'll find that makes normative claims about the law are law review articles, although restatements also clearly usually state some preferences about the type of legal rule that should govern an area or topic. However, even this is not that cut and dry because most law review articles also spend considerable time describing the current state of the law, because their normative arguments just wouldn't be very effective if they failed to do this. For the most part, when you're doing, the traditional meat and potatoes legal research that we do in this course, you'll want to look for sources that are objective or descriptive in nature. It is better to argue from the law as it currently exists if you can. However, it's not uncommon that you may need to make some policy arguments, either because a particular legal issue is unresolved, or even because, maybe the issue just isn't resolved in your favor. In that situation, a source more oriented towards making these normative claims can be helpful. Now, our next category is one that I think is especially useful. We will want to ask ourselves whether a source's coverage is broad or narrow. What array of topics or issues does this particular source cover? What is its scope? The paradigmatic broad source that we run into is the legal encyclopedia. It's so broad that it tries to cover all legal topics for a particular jurisdiction. And the quintessential narrow source are ALRs, which have narrow coverage of a single issue, or perhaps law review articles, which also tend to have a quite narrow thesis as well. Now, most other sources that you run into are just going to be somewhere between these two extremes of broadness and narrowness. Generally, a really broad source will be more useful earlier in your research when what you need to get is an overview of the law, whereas a more narrow source will be more helpful to you once you have done your preliminary analysis and you need to focus your research more acutely upon a single issue or argument. Another important and closely related metric is exhaustiveness. Within its chosen scope, does this source try to collect every relevant source, or does it focus only on the most important or salient cases? Few sources are going to be truly exhaustive these days. Few sources are going to capture everything because there's just too much law to collect and cover. But we see a wide variety of just how exhaustive these various sources can be. We saw a good example of a fairly exhaustive, nearly completely exhaustive source with Wright and Miller earlier in this semester. That particular treatise tries to collect just about every case on any topic within the overall area of federal practice and procedure. CJS is another good example. In many ways, it's pretty similar to our other National Legal Encyclopedia, ANJUR, but it cites substantially more cases. It's much more exhaustive in its coverage. Now, a more concise source with fewer citations, a less exhaustive source, is going to be easier to navigate, and it will usually serve you better earlier in your research when you really want to be directed to those most important cases, those most important primary sources, straight away. A more exhaustive source that cites more primary authorities will be helpful later in your research when you need to double check. You need to make sure that you've found all of the important sources. You don't want to be surprised by some source of law that you just didn't turn up in your research. And that's when those more exhaustive sources can be handy. Now, another key aspect of any secondary source that you find is going to be its authoritativeness. Is this source, the gold standard for a particular area of law? Is it a source that gets cited frequently by courts? Have attorneys relied upon its pronouncements since times immemorial? Or is it more focused on just being useful than getting cited by courts? We've seen some more authoritative sources, such as the Wright and Miller treatise that we looked at, that is the most authoritative treatise in the area of federal practice and procedure, and the immigration law treatise that we looked at on Lexis, Immigration Law and Procedure, which is just widely regarded as an authoritative treatise in that area of law. Those are both just the number one treatises in their respective fields, and Wright and Miller especially is just cited very frequently by the federal courts. Of course, you absolutely need an authoritative treatise if you plan on citing it in a brief or using it in a legal argument directly. But even more generally, an authoritative source is just a more credible source. It's going to have a more accurate description of the law. So, if all else is equal, a more authoritative source is just going to be a better choice for you. But usually all else is just not equal. And you're often going to find that a more authoritative source is just going to be more scholarly and exhaustive as well, so it might not be the best choice if you're doing preliminary analysis and you're trying to get a good and easy overview of the law. Finally, we have the metric of accessibility, and this is sometimes just going to be the dispositive reason for choosing a particular secondary source, because obviously you can't use something that you don't have access to. So you need to be aware of which sources you can access, either through your subscription to Westlaw or Lexis, or in print. You also need to be aware of all your different methods of finding and using the sources that you can access, so you don't inadvertently ignore them or not take advantage of them when they could be useful. This course will help to apprise you of all of those methods and strategies, but they are skills that you need to supplement throughout your legal career. But you also don't want to forget about libraries. Even if you don't immediately have access to a particular, say, authoritative treatise that you might want to use in your research, your local law library might actually have it. And if that's a source that you need, you may want to check out that avenue. Or similarly, even though your law firm might not immediately have a particular source in a way that you can just access it right away, if it's a larger firm that has a library or a librarian, they may be able to obtain it from another library and get you that source so that you can use it. So things are not always necessarily as inaccessible as you might first think. Now, the reason that you want to think about your secondary sources in these terms that we've outlined, the reason these metrics are important is that you want to make sure the source that you choose is actually a good fit for what you are doing in your legal research right now. What is the overall purpose of your research? And what is the more immediate goal that will help you move towards accomplishing that overall purpose? The source you choose needs to match the answers that you give to these questions. So, for example, let's take preliminary analysis of a legal issue in an area of law that we're just not familiar with. For this, we probably want a middle ground in terms of scholarly versus practical. We know that we definitely want a more objective source that describes the state of the law because our normative arguments are just not what we're after when we need an overview. We also want a source that is at least somewhat broad because we just don't know enough about the law to know which narrower issues or sub-issues, elements or aspects of that overarching legal issue are going to end up being more significant. We probably also would want a source overall that would be less exhaustive and more concise so that we can go ahead and focus on those more important sources just more easily at this early stage of our research. And generally, authoritativeness would be good to have. We would probably overall want a more authoritative source, but we also know that often that authoritativeness is going to be correlated with sources that might also be more exhaustive than we would want or more scholarly than we might prefer. So yeah, what is a fairly practical, objective, fairly broad source that is more focused than it is exhaustive? Well, a treatise or a legal encyclopedia. That's going to be your answer. And that's why we tend to reach for these sources for preliminary analysis. But when you do use other types of sources in other stages of your legal research for other purposes, it can be helpful to think of secondary sources in terms of these different metrics to help you similarly clarify just what you're looking for and which source is going to help you find it. Finally, you do need to be critical about the secondary sources you find. Everyone makes mistakes. That includes the attorneys or professors who write the secondary sources that you use. It is definitely not uncommon to run into an error or even just a questionable statement in a secondary source. As a librarian who uses a lot of secondary sources for a lot of different reasons, it's something that I run into every once in a while for sure. So it goes without saying that you do need to carefully read your primary sources that you find through your secondary sources to ensure that those cases and statutes actually match the description you find in your secondary source. You also need to be wary of statements that are, upon closer inspection, maybe less objective than they might initially appear. People do have biases, and they might write treatises and legal encyclopedias that share those biases without explicitly stating that that's what they're doing. So don't take any source, even the most authoritative treatise in the world, at face value. And don't mistake any description of the law for the actual law, which you will need to read closely as you get closer to the end of your research process. So yes, we've talked about evaluating secondary sources in terms of a few key metrics that can help us determine, whether a particular source might be a good fit for what we're trying to accomplish in our legal research, at the time that we need to source. And we've also talked about the need to be critical when we engage in this process of evaluating secondary sources. Okay, that's all I have for now. Until next time.